Hi everyone, my name is Andrea Lee. I'm a healthcare attorney and partner at Honigman. I'm posting these 3-minute webinars in order to update my clients and other healthcare professionals about important healthcare regulatory changes that have been enacted in response to the coronavirus pandemic. Today I'm going to talk about the CARES Act, specifically certain terms and conditions that apply to CARES Act funding that if not complied with can lead to investigation and litigation down the line. At the end of March, the CARES Act allocated $100 billion to healthcare providers to allow them to respond to the coronavirus pandemic. This money was needed urgently, so there wasn't time for a lengthy application process. Instead, the money was direct deposited into healthcare providers' accounts, depending upon how much they had billed Medicare in the prior year. This was the right approach, but it created some complications. HHS created a website that goes through how much providers can expect to receive and when they can expect to receive the money. But if you scroll all the way down to the bottom, it also linked to certain terms and conditions. The website said that if healthcare providers don't return the money within 30 days, they are deemed to accept and comply with these terms and conditions. So why is this a big deal? First, healthcare providers need to know about these terms and conditions, and two, the terms and conditions are really burdensome. They include detailed information on how the money can be spent and how it can't be spent, strict auditing and reporting and record-keeping requirements. So if healthcare providers don't even know that these terms and conditions are out there, it's very unlikely that they're going to meet all these strict and detailed requirements. The government has also come out and said that it's going to be acting aggressively against healthcare providers that fail to comply with these terms and conditions, and it will be bringing significant actions against healthcare providers. The government's under a lot of pressure to make sure these historic funds are used appropriately. The government in these types of situations could bring an investigation against healthcare providers if they fail to comply with the terms and conditions. The government typically uses the False Claims Act, which has really steep penalties. Under the False Claims Act, the government can recoup $22,000 per claim submitted in violation of the terms and conditions. They can also seek treble damages. And employees can also bring whistleblower claims against their employers if they believe that their employers are not complying with the terms and conditions. Those employees can receive up to 25% of any recovery, and the recovery can be millions, if not tens of millions of dollars. So it's very important for healthcare providers to make sure that they're complying with these terms and conditions, and that they're also putting policies and procedures in place to mitigate their risk. I hope this has been helpful. My email is alee2@honigman.com. Please reach out if you have any questions or like assistance on interpreting the terms and conditions or putting policies and procedures in place to mitigate your risk. Please like, share, follow this video if it was helpful. I'm also going to be putting this video on my YouTube page, so I'd love it if you could subscribe. Thank you.